Hi, my name's Doug. I'm going to be explaining asset protection to you today. Now, the first thing you need to look at when you're thinking about asset protection is your basic corporation owning a bank account. Now, a bank account in itself, in an offshore jurisdiction, has a measure of security. Many people ask me, Doug, why don't I just get a personal bank account? What people don't realize is that any wires going into and out of a personal bank account will have your name on it, which utterly destroys any asset protection plan. So what you need is basically a bank account that's in another name, and that's why we use a corporation. We don't just use any type of corporation, we use a bearer share corporation. That means that when we register this corporation, at no time does your name appear anywhere in any of the paperwork. You simply hold the bearer shares. These are physical share certificates, pieces of paper. If you and I were in a room and I handed you the pieces of paper, you would then own the corporation. If you handed the pieces of paper back to me, now I own the corporation. So now you have a corporation owning a foundation in an offshore jurisdiction, and you're under bank secrecy. Life seems great, good asset protection plan, one would think. However, there's definitely some weaknesses in this asset protection plan, and that's why you very rarely see customers going with such a basic asset protection plan. The first problem is that incoming wires and outgoing wires are going in and out of the bank account where your money is stored. This is the first rule in asset protection that I call it the pot of gold rule. My rule is that the pot of gold should not be at the end of the rainbow. In this case, at the end of this rainbow is your pot of gold, and any legal challenges, if someone comes in and attacks, has a legal challenge against this corporation here, the first you find out about it, you're going to have to defend yourself. Any good asset protection plan will not force you to protect yourself for the outer layers. The outer layers should only serve as notification, and your assets should never be at risk. So what we do is we have the corporation owned by a private interest foundation. Now, a foundation here in Panama is sort of like a trust wrapped in a corporate shell. It has no legal owner. It has different roles like a protector, there's beneficiaries. All the different roles you would find in a trust are in a private interest foundation, but it's also got all the legal abilities that a corporation does, except it is not allowed to go out and earn money. The foundation is, however, able to earn a passive income. When I say it can't earn money, what I mean is it is not allowed to go out and start selling, say, widgets on the internet. You can't go out and sell something for money. You can own stocks, you can invest money into investments, and you can also own a corporation, which is what we do to give you the best of both worlds. You have the foundation with all these protection that a foundation brings, owning a corporation that can go out and do just about anything. Now, it's very important how you operate this structure. Any money coming in and going out of this structure should only come in and go out of this bank account right here, the corporation bank account. Your foundation should be registered completely separately, and it shocks me, to be honest with you. There are many law firms that do not pay attention to how they're setting up their foundation and corporation, and there's an easy association between the two which blows the whole concept here, because basically this private interest foundation is going to have a bank account as well, and this is where you're going to store your nest egg. Now, if the foundation owns the corporation, wouldn't it be smart to register the corporation so that it's impossible for anyone investigating this corporation here to determine that it is owned by the foundation? And that's exactly what we do. I'm not going to go into all the technical details, but some of the things that we make sure we do that other law firms are not doing is we make sure that we use different directors from foundation council members, we use different registered agents, and we don't register the corporation and the foundation on the same day. Now this might just sound, I mean, even without being an expert in asset protection, anyone thinking should realize that you don't want an association. If there's any kind of association, when an attack comes, instead of just getting a notification that, hey, the corporation's under attack, you're going to also find out that your foundation's under attack. Now you've got to worry about the assets. If this is set up properly, then there's no possible way for anyone coming after the corporation to find out about the foundation. And what you do to make sure that there's no way for them ever to associate it, we get we'll call this Bank A. And we make sure that we get you the foundation account at the same bank as the corporation. Then what you do is periodically you sweep your money from the bank account of the corporation into the foundation. So now you have a two-layer asset protection plan with a foundation owning a corporation. From externally, there's no way to tell that the foundation owns a corporation. There's no wire records. It's very neat and tidy. Now, there are still some issues with this plan. And the big issue, and most law firms in Panama will not deal with this issue because it's not within their jurisdiction. However, we have integrity, and we know that you need to know this information. And this is what you need to know, a lot of you, not all of you. Depends on where you live. But it turns out that the beneficiary sorry, my pen is not working very well. Technology is failing here. There we go. The beneficiary of a foundation in some jurisdictions is deemed, and which is you, in most law firms this is set up as you, and it is a private role, no one would ever know, but the question is that good enough for you? If that was ever uncovered through whatever method, I don't know, but if that was ever uncovered, it would be a sticky situation for you, because in many jurisdictions the beneficiary is deemed to be the owner. This is a problem because if you, in those same jurisdictions, many of those jurisdictions require you to report if you own a foreign corporation or foundation or trust, or have a controlling interest. So this puts you in a sticky situation. So what we do is we set you up with, now before we go any further, what I want to do is explain the different packages we have in this whole situation. Number one, I'll try to do this in red here. Number one is basically a corporation with a bank account. This package is $17.95, and we are the only law firm that guarantees that you will get the bank account open or we refund your money. Package number two is what you see here all together. Private interest foundation owning a corporation with two bank accounts, and of course you get debit cards and credit cards. And by the way, we can get you credit cards with the corporation name on it only, and no personal name. Your name doesn't appear on the magnetic strip, it doesn't appear on the card, and it doesn't appear anywhere, and there are no high fees. It's a standard secured Visa card, so that's a very handy tool. Call and inquire, and we'll talk about it.